Hello, welcome to CSC 239, Cyber Law, Ethics, and Society. Today we're going to be talking about intellectual property rights. So we need to go back 400 years to when owning property became a thing. Ownership of property was initially legally defined in the 1700s in the Blackstonian Bundle. And that was the bundle of property rights that were finally put down into the law books. And it is defined as an owner has the right to exclude anyone from the property, to use it as he or she sees fit, to receive income derived from the property, or to transfer the property to somebody else. So before that, people had houses, they had various and sundry property type items, but until this was actually codified in law, it didn't actually become a quote-unquote thing. Intellectual property, which is not something you can taste, touch necessarily, it's something that you create in your own mind. And it is intellectual objects such as musical compositions, poems, novels, inventions, product formulas, etc. So one can copyright the expression of a concept, but they cannot copyright the concept itself. So you cannot copyright the idea of all love songs, but you can copyright the song from Titanic, My Heart Will Go On, because it is in fact a specific, unique, and totally created property. In cyberspace, things get a little more complicated, and this is basically what we're going to be addressing today. Many have argued that intellectual property rights that have not kept up with the way the information on the internet is created, shared, and so forth. So, for example, you will like a new song you've heard, you go online and you bypass Google Play or iTunes and you go directly to whatever your favorite site to rip music from is. And again, what we do with these things now is it's so second nature to so many people that they don't even perceive it as theft. But, there's an artist who wrote the song. There's an artist who sang the song. There's an artist who played on the song. There are marketing costs. There are production costs. And all of these costs are usually paid by the product when it sells. But if it's just being stolen, it's not really providing any incentive for the artist to do this work. Now, our old friend Larry Lessig argues that the USA needs to change our understanding of artistic endeavors and creativity. And basically, the reason he's alluding specifically to the United States is because if you go to a country like China, or many of the countries on the continent of Africa, their concept of intellectual property rights or copyright is much different than how we perceive it. But again, and this is where we keep coming back to, if you want to be an artist who supports yourself, you have to be paid for the work and the creations that you develop. So, we're going to initially discuss the philosophical justification for intellectual property laws, sort of the ethics of owning something. So first we're looking at John Locke, who's that handsome fella on the right. He had the labor desert theory, and this is the principle that the person who works hard on unowned materials to make something original should enjoy a reasonable property right in order to reap the rewards of that work. So you have somebody who cuts down a tree and they have some wood. And a lot of people have wood. Okay, didn't mean it that way. But that person then creates something marvelous out of that piece of wood. For example, a new kind of bench, a new kind of table. And, the idea again is that this person used their creativity and they should be compensated for their creativity. Locke limits this principle by adding, people can appropriate this work as long as it doesn't harm the originator or anyone else. So we look at an invention like the car, and we have to go back to the late 1800s to when they were first invented. And since then, people have made all kinds of vehicles and all kinds of cars, and it didn't harm the person who made the first car. So we have to look at it from the point of, you deserve to benefit from something that you create. Then there's Georg Hegel's personality theory, and he's looking like got a comb over there on the right. He argues that freedom is often defined by producing something, i.e. property. Property, then, is a manifestation of one's personality, is an extension of one's being. So he is tying that property that you create, that intellectual property, to who you are, your specific identity, meaning that for your identity, you need to produce this kind of thing, and as such, you should be rewarded or compensated for it. And then finally, utilitarianism, which we've talked extensively about in this class. The greatest good for the greatest number of people. People need to acquire, possess, and use things to achieve some degree of happiness. People need to feel secure in their possessions. Property rights are then a tool to help people feel secure in what they own and what they create. Intellectual property rights also create an incentive for the time and energy it takes to create something, otherwise known as the return on investment. So if you spend 2 years working on a novel and you get an editor and you get a publisher and they publish the novel and you start making money, that pays off those 2 years of blood, sweat, and tears. But if you just put it up for free on the internet, which a lot of people do to get noticed, then that is their choice, because it's their choice. It's not the public's choice. So let's talk about the legal protection for intellectual property in the United States, starting off with copyright laws, which give authors exclusive rights to their works, and it lasts for the length of the author's life plus 70 years. So Tom Wolfe is a writer who just passed away, literally in the last couple of weeks, and this is 2018 in the spring. His copyrights are going to be good for another 70 years. So for whomever is listening to this, you'll probably either be a very old person or you'll be dead by the time his copyright ends. It applies to literary, musical, dramatic, artistic, architectural, audio-visual works, and any derivatives. So for example, you turn a movie into a Broadway show or a Broadway show into a movie. It cannot be reproduced without the permission of the copyright holder. So you know how they have school plays and they always seem kind of like the same 6 or 7 school plays. It's because you have to pay for the right to put on that play at your high school. And then, the more expensive plays don't get put on as much as the plays that are relatively inexpensive that schools can afford. Lastly, to be eligible for copyright, it must be independently created by the authors or creators. So, again, you're writing something and you give it to your friend to look at, and your friend steals it and tries to copyright it. You can then sue them because they are violating your legal protection. Now, in all of this legal protection for copyright, we also have what's known as the fair use doctrine. And you'll see over there on the right-hand side in my little picture, I have highlighted the words fair use, which you've probably never noticed before. Fair use doctrine states that copyrighted works can be quoted or small segments of a video can be used for limited purposes. For example, a teacher can make copies of a few pages of a book, but cannot reproduce and distribute the whole book for his or her students. So, for example, in this class, I had posted chapter 1 for you, just so that you would have time to order and get your books. That is completely considered fair use because theoretically then you went and got your book and purchased it yourself. Other fair uses include parody, which is, basically everything Weird Al Yankovic has ever done. And if you don't know who Weird Al Yankovic is, go on YouTube, look him up, check out some of his stuff. He basically makes songs that sound like some big celebrity song but are actually nonsense and silly and funny. Consumers can make a copy for their own use. For example, when we DVR a show on TV to watch it later. And we all experience this when we buy our textbook used. People can sell a book or video they have previously purchased without permission, such as buying used textbooks. The next type of legal protection that we're going to talk about is, or are, patents. And they protect physical objects, like machines and inventions, along with the processes for producing the physical product. It prevents anyone else from making, using, offering for sale, or selling the invention for 20 years from the date of filing the patent application. And this is a picture on the right-hand side from 1880 of the first handcuffs that were patented. And again, there's the date of the patent, the number of the patent, and then there's the signatures. But the point being is, everything that's ever been invented in a physical sense has a patent, has one of these types of drawings associated with it. To be eligible for a patent, the product must be new and unknown to others, be useful. It cannot be previously described by others in printed publication, and it must satisfy the concept of non-obviousness. So, for example, you are the inventor of the couch, woohoo! And a competitor tries to take out a patent for a couch, but it is in a different color. Ooh! This is an obvious alteration of the original product, and it would not qualify as non-obvious. Now, if that person took your invention of the couch and they added a cooler to the center where the armrest is, that could qualify for a patent because that's not something that is necessarily obvious. Laws of nature, algorithms, scientific principles are not eligible for patents. In recent years, patents have been given for bioengineered plant species, surgical procedures, and software programs, despite containing algorithms. Although many patents can create a temporary monopoly for a company, it allows companies to recoup their often massive investment in research and development. And this is especially true in the pharmaceutical industry, where they might spend $100 million to develop a particular kind of medication for heart disease, and they need a certain amount of time to recoup all of that money that they have spent figuring out how to make this medication. The Cohen-Boyer patents were invented by Stanley Cohen of Stanford University and Herbert Boyer of University of California, San Francisco. The patents cover inventions for splicing genes to make recombinant proteins. Very exciting stuff, and they figured this out in the 70s, which was pretty amazing. Stanford managed the patents and licensed them broadly, earning just about $200 million for the universities. That is what universities ultimately want their researchers to be doing, is to figure out something that they can patent or copyright, and then it'll help the university continue to make money. This patent does eventually go away, and as such, Stanford only had a very short amount of time, and the University of California, to recoup their losses, which I think came to about 17 years. So, legal protection for intellectual property in the USA include what we call trademarks, and most of us see yellow arches in the distance, and we know that's McDonald's. We see the swoosh, and we know it's Nike. So a trademark is a word, phrase, or symbol that represents a product or service. To qualify as a trademark, it must be distinctive. So, a red cross in the middle of a white flag, we know is the Red Cross. But if we put a lot of little red crosses on that white flag, it's no longer the Red Cross because it doesn't have that distinctive look. Trademark infringement takes place if a company takes a symbol that is associated with another company. For example, if a shoe company tries to use the Nike swoosh by making the swoosh slightly different. So these trademarks get infringed because a reasonable customer could be confused. So you go into a store. Let's say you go into a store in Spain or Portugal, and you see what you think is the Coca-Cola logo because you don't have your glasses on, but instead you're buying Chica Loca, which, by the way, is not Coca-Cola. And as such, you will probably be disappointed. Then, of course, there's the McDowell's, which clearly supposed to look like McDonald's, but it's different enough that they tried to say it didn't infringe. And then my personal favorite, the Stars and Bucks Cafe, and they are using the exact same color scheme as Starbucks. Trademark law does allow for fair use and for parody. So here's some of the parodies that you can find, and there's a million of them. Instead of Yahoo, we have Yahoo, the crappiest search engine on the web. And then North Face and South Butt, which really is just hilarious. American Expense instead of American Express. And then my personal favorite is instead of a puma, it's a poodle. But these are clearly meant as parody and not as a way of fooling the customer. If you don't get the joke, that's your fault. So I wanted to talk about some of the case studies that have come up with intellectual property rights. So we're going to start with Napster. And some of you may be old enough to remember that Napster was the place to go. And others of you may be like, who's Napster and why is there a cat wearing earphones? Well, Napster allowed users to search for a particular piece of music from other Napster users' system as long as they had installed the Napster file sharing software, which was free. Once the piece of music was located, the song could be downloaded on the user's hard drive. So basically, in a sense, what it did was you had the opportunity. So let's say, again, you hear a new song on the radio and you really like it. You would go to Napster, you put in the song title, and it would bounce from server to server to see who amongst the millions of users already had downloaded a copy of the song. And then you would download it and you'd go on with your day. There's only one problem. It was kind of illegal. So here's a picture of what Napster used to look like. It did not store digital music on its own files, and it was also not copying the music files. They maintained, and this is the big important thing, because those of you who are BitTorrent users will say, well, we still can do that. Napster maintained a central directory of all the music available among Napster users. So basically it compiled a database of what was available instead of it just being, a search thing. In 1999, the Recording Industry Association of America, otherwise known as the RIAA, sued Napster for contributing to copyright violation. And then on the heels of that, in 2000, the band Metallica, and those are those folks in the picture, also sued Napster for copyright violation. Napster's legal team argued that Napster users were engaging in fair use of the music. And there are 4 conditions for fair use in court cases. 1. Purpose of use. Is it for commercial gain or for personal use? Number 2. The nature of the work. Is it creative versus factual creations? If you are looking at a chart that somebody created about the gross domestic product of the United States and you want to use that, that's fair use because it's not creative. It's based on fact. The amount used compared to the full amount of the work, so if I give you 10 pages out of a 1,000-page book, it's infinitesimal how little of the work you're actually getting for free. And the effects of the use on the marketing of the work, and this is the important thing. Fair use should not materially impair the marketability of the work which is copied. So, you're not selling the music and it's being taken for free, it definitely impacts the marketability. Napster also argued that Napster users downloaded a song to decide if they want to purchase the whole CD. And they also said that Napster users downloaded MP3 files to listen to music they already owned on CD, which is akin to engaging in time shifting, such as when the TV viewers used to use VCRs to record shows to watch later. And remember, in 2000, VCRs weren't completely dead yet. So the legal decision, the court found that Napster did encourage and assist in the infringement of copyrights, rejecting its fair use claim. After this ruling, Napster converted their business model to one that is similar to Apple iTunes and Google Play, where you have to go and you actually have to buy the stuff. So, did this decision stop file sharing? Of course not. I'm sure most of you have a phone full of music that has been borrowed from other people. Today it is known as P2P or peer-to-peer. The model does not have a centralized server that manages the file sharing. That's why they can get away with it. The user can log into a P2P network, search the other computers that are on the peer-to-peer network for the file they are looking for. The search goes from computer to computer until it locates the file. So the major difference between what we're doing with peer-to-peer versus Napster is that there's no centralized server where everything comes through or goes out. Organizations like the recording industry have fought the peer-to-peer suppliers like BitTorrent and LimeWire, and in 2010 a U.S. court shut LimeWire down for violating copyrights. In 2018, the legal aggregation site lexmachina.com found that over half the copyright violations that are filed by pornography websites against BitTorrent users. So essentially, and of course, the irony is there's so much free pornography, why do you need to steal it? But nonetheless, if you have a particular interest, I'm sure the interest there, it's not the big studios like Paramount or Universal Studios or Disney that are necessarily going after the users. It's people who are using BitTorrent to borrow or own their own copy of whatever pornography they personally enjoy the most. Another case study, and this involves a company called DeCSS or DeCSS software, and it is a software that was created to allow decryption of DVDs. Its developer claimed it was to allow him to watch his DVDs on his computer, which ran Linux. In general, most DVDs are only compatible with Windows and Apple operating systems. He posted his code on the internet and offered it for free to anyone who wanted it. And that is where things kind of got a little sticky. In the Locke case, Universal City versus Remedios, the plaintiffs, who were the movie studios, claimed that DeCSS software violated the Digital Millennium Copyright Act because the software was created to jailbreak the DVDs. And here's basically what the Discrambler looks like in terms of how it worked. The defense team claimed freedom of speech. The plaintiffs argued that software code is more functional than expressive. The judge ruled in favor of the plaintiff, saying that DeCSS violated the Digital Millennium Copyright Act. They also said that the software did not convey a message, rather it was a functional and not worthy of free speech protection. So in this case, it was meant to violate copyright. It was not meant to convey a message so much, in terms of it wasn't there appropriated to use it in a particular song or another art form. And of course, every time there is a company shut down or they lose a court case, somebody else figures out another way to work around copyrights. And there are several movements that aim to work around these laws using code. Companies that produce digital media have responded with limiting the fair use doctrine with their own code. So, and again, every time you have a consumer who figures out how to get something violate the copyright or the intellectual property rights, the companies respond with their own fixes. But they're not really getting out in front of the problem because they don't necessarily have the time and the skill sets that these people who are dedicated to freeing information do. First one is the open source code movement. Now, most software does not fit neatly into any of the current intellectual property protections. Written in a specific language, such as C++ or Java, it can be considered literary, but it is also functional, and that makes it inconsistent with copyright law. It is not worthy of a patent because although it is functional, it is not an expressive literary work. Also, software is often innovative, but it's not in and of itself an invention. So consequently, Free Software Foundation is an organization that argues that all software should be free. They claim that owning software is obstructive and counterproductive. The general idea behind the open source code movement is not only should software be distributed for free, but the source code should be available to anyone who wants to modify it. So in this sense, if you think of all of the free apps that are available on iTunes or Google Play, you download the app, it's free. You're like, woohoo! How are the people who made the app making any money? Well, there's two general ways. There's in-app purchases, which, you're playing Angry Birds and you need some more lives so you can kill all the pigs or whatever, and suddenly you find yourself spending $5 for an unlimited hour of play. So that's one option. The second option is that in a lot of apps, you'll have little advertisements that are running at the bottom of the screen, or that your game gets interrupted to watch a 30-second advertisement. And again, those advertisements are paying for you to get your software for free. Open source licenses contain 5 key provisions: the freedom to run the program for any purpose, the freedom to access the source code to modify it, the freedom to redistribute copies of the program, the freedom to release modifications to the public, and what we call the Copyleft Provision, which I'll explain in more detail. keeping in mind all of these things, if you've ever made a website from scratch, so to speak, and you need a particular way of putting in, payment, like PayPal or something. Well, if you Google something, PayPal script, you're going to get it. And then you just copy and paste it into your own website. Again, the point being is they're going to make their money one way or the other. And if you become a PayPal customer, they're going to be taking money from every transaction. So they are happy to give out their software. So a copyleft provision allows a user to redistribute the open source code with modifications, but only under the same open source license. This prevents users from copywriting modifications to their source code. So you get some free software, you start modifying it, you're doing all kinds of cool stuff to it, and you get to the point where you're like, hey, this is really awesome. I'm going to charge people $10 to get this. Well, you have just violated the copyleft provision of fair use. Another option that has been used is called the trusted system architecture. Some content providers have moved towards a trusted system. Content providers distribute their content in cyberspace in encrypted form so that it is accessible only by users who have a trusted system. So if you ever try to download on your phone something that should be on the Kindle, you might encounter problems, but you can then download the Kindle app, because again, the idea is that now that you have the Kindle app, you can start spending money on the books that Amazon wants you to buy. Another biggie, and oh man, people get so mad about this, digital rights management, or DRM. Rights management is the ability of the publisher of a work to define what rights subsequent users of their work will have to use, copy, or edit the work. In terms of music, you buy the CD. You may only be able to burn 3 copies out of that because there is a digital rights management code on the CD that counts how many times it's copied. So a lot of times what you'll get are people who, they buy the CD and they're going to make copies for their 20 closest friends, and they discovered they can't do that, and it becomes a very frustrating experience. And then people will figure out how to break the DRM, because that's what people do. The problem with both DRM and trusted systems is that it inhibits the consumer's right to fair use. So if you, for example, have a piece of software that you are allowed to copy no more than 3 times, and you do copy it 3 times, and you give a copy to your mom, and you give a copy to your brother, and you give an extra copy to your girlfriend or boyfriend or both, and then the software, you go to make a 4th copy for yourself, and it has inhibited your right to make that copy. So there are lots and lots of lovely conversations about whether or not it is an invasion of our privacy. So we're going to move on to some of the legal issues with domain names. The definition of a domain name is the equivalent of a telephone number or an address for a website. So google.com, pit.edu, which is our college website, youtube.com. So there are all kinds of domain names out there. The big problem with domain names is cybersquatting, and this is a legal issue that a lot of people have had to deal with. Cybersquatting means that a person will register a domain name with the intention to resell the domain name to a party that has a claim to that name. Cybersquatters also do this with names that could be confused for a particular name. The idea is to profit by jumping on a domain name that somebody will want. So, for example, if you expect certain politicians to run for president at the next election, you could potentially go ahead and buy their name and for president and make it a website that you are just holding on to, and they would have to come to you and say, hey, I want this website. And then you will try to make a ton of money off of how much they need and want this website. So in 2000, Julia Roberts sued and won the right to control the domain name juliaroberts.com. In 2000, the BBC won back the rights to their domain name, bbcnews.com, after it was registered by a cybersquatter. And this was very prevalent in the early days of the internet because not everybody truly understood what the internet could do in terms of marketing and putting yourself out there in terms of being a celebrity or a artist. You don't see it as much nowadays, but you do see it with things like politicians who may or may not be running for certain offices. In 2008, Verizon won a lawsuit over the domain names, which included myverizonwireless.com, iPhoneVerizonPlans.com, and VerizonCellular.com. So somebody had gone out and registered those names, and Verizon wanted them back. So, if you're not willing to pay exorbitant fees to get it back, then you take them to court. And oftentimes you have to have a nice little bank account to take them to court anyway, because, paying them directly feels much more like blackmail or extortion. So what's the big deal about cybersquatting anyway? At the core of the disputes involving cybersquatters is the freedom of speech versus the legitimate claims of trademark holders. So if somebody registers the name www.mcdonaldskills.com, is that an editorial perspective, i.e. free speech, or is it violating the McDonald's trademark and, McDonald's really doesn't want this website out there? So a lot of times these companies will buy up. For example, Comcast Sucks was one that was very popular until Comcast changed their name. And again, it is always a dance between the person who's doing this and the company, trying to figure out how to outmaneuver one another. So what is the government doing? Well, remember ICANN, the organization that manages the domain name registrars? They have developed a process for handling disputes, and it is called the Uniform Dispute Resolution Procedure, UDRP, and it sets the criteria to determine if someone has a right to a domain name. So what is the legal standard? So far, the legal decisions have come down on the side of free speech unless the domain name is confusing and misleads the consumer. Singer Lady Gaga filed a suit claiming that she should be able to control ladygaga.org, which is a fan-run website. She lost the lawsuit because the site clearly states it is fan-run and it does not try to make any money off of her name. In other words, it's not a commercial site. It's just I love Lady Gaga and I'm going to post 5 million pictures of her and talk about her constantly. So in this case, if there's no commercial issue in terms of buying or selling, you're generally going to see them come down on the side of free speech. So if somebody puts together a website that proclaims, for example, that Justin Bieber is a jerk.com, and they don't make any money off of it, it's not a big deal. Except to Justin, who probably is crying. The UDRP has identified 4 elements of bad faith. Number 1, the domain name was registered for the purpose of selling it for more than out-of-pocket expenses. You buy a domain name from GoDaddy, for example, and it's going to be $50, $60, $70 depending on what package you buy. If you are holding it hostage for a celebrity or a politician, you want $5,000, $7,000. So again, it's that kind of overly zealousness of capitalism. The domain buyer has demonstrated a consistent pattern of registering domain names to prevent someone else from owning them. The domain name was registered to disrupt a competitor. The domain name has been registered to intentionally cause confusion. One of the big ones that basically comes down to the fact that it was considered free speech is if you go to whitehouse.gov, you're going to see all about our president and vice president and the government and all that kind of fun stuff. But if you go to whitehouse.com, on the other hand, it's porn. And as such, there's been a lot of conversation about this, and what the whitehouse.com is basically saying is that we have been around longer than whitehouse.gov, and we're going to continue to be around. And it comes down to free speech, and that they're not making a buck off of pretending to be the White House. Another government action that was done is in 1999, Congress passed the Anti-Cybersquatting Consumer Protection Act, or the ACPA. It says that a person is liable for civil action if a cybersquatter does one of two things. One, has a bad faith intent to profit from the domain name, and two, registers and or uses a domain name that is confusingly similar to one another. So it's very much like the previous governmental actions that have been set up by the ICANN organization. So the ACPA also protects a person's private name from bad faith registration, and it does allow a domain name to mock or criticize as long as there is no intent to commercialize the site. A couple recent examples, obamasucks.ws, and a more recent one, corrupt.af. And that is a anti-Donald Trump website, so you can decide from there if you want to visit either one of those. To just finish up the conversation, what we're looking at here is, again, this brave new world of how do people get around the law, and how do companies constantly try to keep up with the criminals, or the consumers who just don't want to have to pay exorbitant prices. One of the things that we've seen in the last 20 years since the internet became, really a day-to-day experience for most of us, is that the music artists know that we are borrowing their music, stealing it, and have in fact started making money, therefore, not on the music that they sell, but on concert tickets. So you go see a musical act and it's $180, $200, $300 to see Rihanna. And that's how they're making their money. Because you want to see them in person, you gotta pay. You can't steal that. So it changes society, it changes the way we do things. So that's it for today. If you have any questions, please email or text me. If you are not in my class but do have a question, please leave a comment and I will respond as quickly as I can. Thank you and have a fabulous day.